everyone, and welcome. And we are very glad to be here with you today. I'm Christina Jump, and I am the Civil Litigation Department Head for the Constitutional Law Center for Muslims in America. And I'm here today as well with my colleague, Leila Mustafa.
Hi, everyone. I'm Leila, and I'm a Civil Litigation Staff Attorney at the Constitutional Law Center as well. Thanks for being with us.
And we're glad to have you here today. As you can see, we are still sheltering in place at home, and so welcome to our homes. And so we apologize in advance if you hear any children or dogs or any of the other distractions that do exist in the background being more loud and obvious, but hopefully we'll keep that to a minimum and we'll be able to get through to our presentation. We want to talk to you about no fly, no reason. What happens if you're on the no-fly list? How are you going to know, and what can you do about it? So Leila's going to start us off by giving us an overview.
So there are various federal agencies at play when it comes to the watch list and all the subsets of it. One of the main ones is the Transportation Security Administration, known as the TSA, and it's housed under the Department of Homeland Security, known as DHS. Both agencies were founded shortly after 9/11 and the September 11th attacks, just so that the government could really concentrate on preventing terrorism and enhancing security, rather than leaving it to airlines or private terminals to oversee those, which was done before 9/11. So the Terrorist Screening Center is the agency that houses the terrorist screening database, which is commonly referred to as the Watchlist or the Consolidated Watchlist. The Terrorist Screening Center is a multi-agency center administered by the FBI or Federal Bureau of Investigation, and it consolidates information from various federal agencies that try to nominate individuals that they believe are worthy of inclusion within the terror screening database. The TSC itself is the agency responsible for including someone. So they receive criteria from all these agencies and they determine if the minimum standards are met. Various agencies consult the screening center prior to granting benefits to certain individuals, such as the TSA will have to consult the TSDB prior to allowing persons to travel to see if that person is permitted to travel or if they're going to need additional security. The Department of State would consult it to see if people are eligible for visas. The Department of Defense would consult it to see if people are eligible to access military bases. So various agencies use this list. So is there only one watch list? The easiest way to think about it is a consolidated list with subsets. So two known ones are the no-fly list and the selectee list. The no-fly list is true to its name. Those persons are not allowed to fly in the country or outside of the country. The selectee list are for people that have to go through enhanced security screening prior to traveling. So the TSC is the one that determines if the minimum criteria is met for these subsets of the lists. So for the no-fly list, there needs to be a credible threat that the person is capable of committing an act of terrorism, versus the selectee list where there is no stated criteria due to national security concerns. But we have noticed that people are more likely to be on the selectee list if they've denied becoming an FBI informant or things of that nature where they know someone at a mosque that is suspicious to the government as well, or if they donate to charities that the government finds suspicious. Those are some things we've noticed, but there is no stated criteria. So if you're on the no-fly list, you won't even make it to security. You're likely to be escorted out of the airport prior to that time. You probably can't purchase a ticket online, but even if you can, once you go to the ticketing counter, you will be escorted out of the airport. You may also learn that you're on this list based on attempted travels by car or sea to other countries. We've noticed some of our clients have been redirected by trying to drive into Canada due to placements on the no-fly list. So it does impact other avenues of travel as well. If you're on the selectee list, you can fly. So it may take 8 hours, but eventually you will be able to fly. You probably aren't going to make the flight you originally planned on. You probably won't be able to obtain a boarding pass at a kiosk, and will also have to talk to someone take a couple hours before they are given permission to grant you a boarding pass. And once you get that boarding pass, you're likely to see 4 S's on it, which is for secondary security screening selection. Your items are more likely to be individually searched at the security checkpoint. You may be subjected to pat-down searches. And once you're at the gate of the plane, an alarm may sound once your boarding pass is scanned, and you may find agents waiting for you. But you can still fly, and people on the no-fly list won't get to go through those steps at all. So is it ever random screening? You know, a lot of our clients complain, I'm always randomly selected. And you're right, it's probably not random. It likely means you're on the selectee list. It could mean that you're on another unpublished subset of the terror screening database. But there is a chance that if it happens once every 6 years, that it is truly random. But if it is happening to the point where you have to ask, it most likely is not random. You are probably included in the terror screening database. So what can you do? Shortly, Christy will talk to you about certain remedies and recourse that you have, but we just wanted to point you to an administrative process that you do have, which is the Department of Homeland Security's Traveler Redress Inquiry Program, DHS TRIP for short, easier to go by. And this is the remedy that you can take administratively to challenge this placement and learn more about it. So I'll leave it to Christy to tell you more about these lists and what you can do.
Okay, thanks, Leila. Thanks very much. And we are going to get through what some of these lists are and what the practical implications are for you and what remedies you may have available to you. Now, again, Leila talked about how if you're on the no-fly list, you are not going to be able to fly at all. You probably won't get through security. One other thing as well is that DHS TRIP, if you are to file for redress, is required to tell you whether you are on the no-fly list or not. So if you begin the DHS TRIP procedure and you say that you want to know if you're on the no-fly list or not, they are required to tell you if you're on it or if you're not. And then if you ask again for the reasons, then they are required to give you an unclassified summary of what the reasons are so that you have your constitutional right to challenge that and have an opportunity to prove those allegations wrong or prove that reasoning wrong, or at least address what the concerns are. That is the theory of how it's supposed to work. It does not always work that way, and it did not always work that way in the past as well. This was not the case until about 2014, and due to some litigation by some other groups, which predated CLCMA, but we're glad they did it, the government became required to at least confirm whether individuals are in fact on the no-fly list and give them the reasons to the extent that they can without revealing any classified information. Still, a lot of times DHS will avoid telling you as much as it can. You can see here, this is an actual letter that one of our clients received, and he gave us permission to share it. This letter dates to 2017, and it lists that he is in fact on the no-fly list, and then just cites to the statute and the statutory language instead of stating anything else. So in this instance, we followed up and we pushed again to try to get the actual reasons why instead of just the statement that he fit the statutory definition. Now, how will you know if you're on the selectee list? Well, officially you won't, but as Leila mentioned, you'll probably see the 4 S's on your boarding pass, and you'll have difficulty getting to your flight and maybe even to the gate. And realistically, just everything takes longer in life. And you might suddenly have a new best friend FBI agent show up who wants to talk to you. And who doesn't say there's anything wrong, we just want to have a conversation. Can we please come into your house and have a conversation? In that situation, we do generally, as I'm sure you'll hear Charles Swift, our director, discuss in some other topics, we recommend that you not invite the FBI into your house. You can step out onto your porch. And we also strongly recommend that you not have a conversation with the FBI without an attorney present. You wouldn't say, no, I'm not going to talk to you. That doesn't usually go to good places. But you can say, yes, of course, I will speak to you. I'd be glad to speak with you, of course, with my attorney present. So give me your information and I'll have an attorney contact you and we'll set it up. And that does seem to protect you a little bit more. If you are on the selectee list, you also will learn, or any watch list, you will learn that you are on the selectee list because it'll just start impacting other parts of your life as well. Renewing anything will probably become more cumbersome, more time consuming, and more difficult. Passports, even if you just want to do something simple like get additional pages, that likely will take longer. Clearances, government clearances for purchasing a gun or for any required work credentials may take additional time. And it won't be stopped necessarily. You might not be told a reason, but it will just seem like everything takes an awful lot longer than it used to or than it does for those around you. And those friendly neighborhood FBI agents might also be showing up to talk to your friends and family members and coworkers and asking questions about you as well. Now, can you get off these lists? Well, as to the no-fly list, can you get off the no-fly list? We cannot guarantee any results. And so let us begin with that. We cannot promise any particular result for any particular individual. Every single situation is different, and we can't predict which way it'll go. But we can tell you that yes, it is possible to get off the no-fly list. And this same client who said that we could share his prior letter said that we can share his letter here as well. And this letter indicates that he is no longer on the no-fly list. Sometimes that really does happen. And I would say that to date, we've had roughly 8 clients who have received a letter similar to this. Now, sometimes it won't specifically say, we have now determined that there is no longer a reason to have you on the no-fly list, or we have taken you off the no-fly list. It might not say that. It might say we've reviewed our records and we've come to the conclusion that there is no reason you cannot travel. And that means that you are not on the no-fly list, because they'd be required to tell you if you were. So that is something that's also helpful. So it is possible. It's good to know. If you ever get a letter like this, I do recommend, and one thing that we advise clients to do is keep a color photocopy of it in your wallet when you travel. So if you do begin to have problems, you can say, look, I know I'm not on the list. See, and here's this letter I have, a nice DHS stationery showing that I'm not on the list. It says I shouldn't have problems traveling. Always, it's worth it. It may not solve all problems, but it's worthwhile to have that with you. Can you get off the selectee list? That's more complicated. Yes, you can. You absolutely can, but you might not know why, and it's harder to do. The issue for that, the reason for that, is that the government still usually does not specifically acknowledge if you are on a watch list, unlike with the no-fly list where they're required to tell you. And the government agencies also don't have to reveal any reasons, and you may not have a clear opportunity to challenge anything because you haven't been given specific reasons, so you don't know what to challenge. And the government may not confirm if any changes have been made. The language that we typically see in that situation is a letter coming back saying, we have reviewed all of our databases and records, and we have made any changes that may have been necessary. Doesn't mean any changes were made. Doesn't mean that it got better or worse. It just means that they're telling you to trust them, and to the extent that anything did need to be changed, they did it, possibly. So you're not going to learn as much. It's not as heartwarming. It doesn't have the sense of closure at the end. But generally, we do have clients who can tell that at the end of some of these processes, then suddenly their travel gets easier. Things start getting renewed again without as many problems. Their lives go a little bit more simple, and they don't necessarily have FBI agents showing up to talk to all of their friends and relatives anymore. So it is possible. And you can still sue if you wanted to, for the denial of some of your liberties or the infringements on your liberties that being on the selectee list may cause you. You'll have to go through the exhausting the required process, but again, you're going to be a little bit more in the dark. So it's a little bit of a harder sell to the judge to explain where the harm was to you, and for sure that it's because of the government's actions, and for sure that it's because they don't have a really good reason, because you still won't know the reason. Leila referred to, and we've discussed, DHS TRIP, which is the Department of Homeland Security's Traveler Redress Inquiry Program, so TRIP for short. And DHS TRIP is the only administrative avenue that is available. It's the only administrative remedy that is available for individuals to challenge any travel difficulties that they're having, or their placement on the no-fly list or on the watch list. So it is the place you have to start. Now, you may have heard that some court decisions and some judges have said, look, this is so burdensome. You don't have to go all the way through that because it's not going to result in anything good anyway. Some judges feel that way. I think there's a handful of those across the country that have issued holdings along the lines with that. But none of them have said you don't have to start it. You have to start it. You have to start the exhaustion of the administrative process that is available, even if it doesn't get you everything. And most judges will want you to do more. They will want you to proceed with the administrative process as much as you can, or at least show that you put in a good faith effort to try to resolve the issue and to proceed as far as you had the ability to take it with the administrative process before you file a lawsuit or try to bring any kind of action before a judge. They want to know that you gave it your best shot. You tried as much as you could. And if there was a problem, then you can say that it was the fault of inaction on the government's part, but certainly not yours. Now, if you do apply for redress or for solution through DHS TRIP, what do you need to have in order to apply? Now, what's on the screen here is a whole bunch of stuff here, but we wanted to show you because this is what one of the screens will look like that you will see. And you can check all of the boxes that apply. There could be more than one that applies. For example, you might click that you were denied boarding and that you always have additional problems. Or you were unable to print a boarding pass and you were eventually denied boarding. You're directed to the ticket counter every time and you're unable to print a boarding pass and you're always subjected to that random screening. There may be multiple combination of things that you check. And if you continue down toward the bottom of it, then I feel my civil rights have been violated. That may quite likely be something that you feel is appropriate as well. We do advise that people check as many of these boxes as they feel are relevant. It's a good recommendation just to cover all of the bases that you think do apply. We also suggest that you attach a separate page, and it can be just one page. It can have just, even 2 short paragraphs, but discussing in narrative form, in paragraph form, what the story is. Tell the story to whoever is going to receive this and be reading it. And that helps you later on down the road. It also helps to give the fuller picture, and it helps you explain what really is the problem, as opposed to being limited to just the terms that you see here on the screen in those boxes. Now, if you are a United States citizen, or if you are a lawful permanent resident, we recommend that if you have a U.S. passport, you provide a color photocopy of that U.S. passport to go along with your DHS trip application. If you're a lawful permanent resident, we recommend that you provide color copy, or at least a very clear copy, that you would upload as well. That shows that you are a lawful permanent resident. And that identification, even though it's not specifically required, will help your DHS trip application get processed a little bit faster. Now, why is that? Why would it get processed faster if you're a lawful permanent resident or a U.S. citizen? Well, that's because the U.S. government draws a distinction, and it affects who gets what redress here, even through DHS trip. This distinction is not listed on the website. It's not addressed through the website. The website says anybody can apply, and that's true. Anybody can apply through DHS trip, but only U.S. persons are going to actually get a remedy. A U.S. person defined by the government is anyone who is a United States citizen or a lawful permanent resident. And those people, in the eyes of the government, are the only ones who they are required to tell whether you are on the no-fly list and what the supporting reasons are to the extent that an unclassified summary is available. As to everybody else who's considered a non-U.S. person, that's people who are here illegally, that's people who are here legally, but maybe you're here on a work visa, maybe you're here on a student visa, maybe you're here on vacation, you're here for any other reason, you're here any other way, other than being a lawful permanent resident or a U.S. citizen, then you absolutely are welcome to apply for redress through DHS trip, but you're not going to get any. So they will let you apply. They won't give you any answers. You will get the very vague letters that we referred to earlier that will say, we have made any adjustments that may have been necessary. Also, another unfortunate aspect of this is that for those who are considered non-U.S. persons, so not citizens and not lawful permanent residents, we have seen as well that even though you're not going to get a remedy through this process, before the government tells you that, the government will ask for a whole bunch more information. And they will ask for information such as every address that you've had, everyone who has lived with you at those addresses over the past 10 years, each of your landlord's names, copies of each of the lease agreements that you've had, all of your family members and their addresses, and a whole bunch of other things that we recommend our clients not submit because it's not going to get them redress anyway. And in our minds, it just leads to unnecessary intrusions and quite the fishing expedition on the part of the government. You may want an attorney for this. You can begin a DHS trip application for redress without having an attorney to help you. You absolutely can do that. And you are welcome to go ahead and try it and start it that way. There's really no harm in beginning it that way on your own and without an attorney. Being represented will bring your application effectively to the top of the stack. We do note that they get more attention. Also, it's confusing. The relevant rules are not all published in one place. It took us, I believe, when we began pursuing these, about a year to figure out the entire administrative process and what the different steps were and what is required or isn't required and in what sequence it's required and then where you can go next, because it's not all published in one nice neat place. Another advantage of having an attorney is that attorneys can hold agencies accountable to their deadlines. DHS TRIP has printed guidelines for themselves where they recommend that they will get you an answer within 30 days. They will get you an answer if you time the appeal within another 30 days. That they will take action at set intervals of time. And when they aren't doing that, and lately they are not, part of the reason for that is because they are in fact overwhelmed. There's more volume than they have, I believe, people to get through, at least with the way that they're doing it. So there are delays. But if you have an attorney who can hold the agencies accountable for those deadlines, then maybe your delay will be less, and that may help. Also, if it's an extensive delay, you may want to have an attorney who can help you with filing a petition for writ of mandamus. Now, what that is a lawsuit that's filed in federal court, and it's not on the substance of whether you're on the no-fly list or the selectee list or why or whether those reasons are valid. It's a complaint that you file asking a federal judge to issue an order to the government agency instructing the agency to take the steps in that process, to finish the administrative process. So to give you an answer as to whether or not you are on the list, to process the appeal and give you an administrative hearing if you've asked for one and if you're entitled to it. So having an attorney who can bring that to a judge to say, look, they're not even doing their part. I'm trying, they're not doing their part, certainly does help make things go a little bit faster. And you do still want to exhaust your administrative remedies. Failing to do that can be fatal or at least really detrimental to any future action that you might have or that you might want to bring. A judge will want to know that you did your best to get everything done on time and the right way before you bring anything to the attention of the judge. The judges don't necessarily want to know that you took too much time, that you didn't even try, that you filed it and you didn't hear anything within 5 days, so then you filed a lawsuit. That's not going to go over well for the judge. All right, well, we want to thank you. We were glad to have you come with us. We're glad to share the information with you. You can also go to our website at CLCMA.org, and we recommend that you take a look at that. That's where our intake form is, and that's where we direct all potential clients if they do want to seek representation. We will send everybody to fill out the intake form on the website. So please feel free to go ahead and do that if you have any further questions or anything needed. And you can, our contact information is contained on the website as well. Again, I'm Christina Jump. I am the Civil Litigation Department Head for the Constitutional Law Center, and I'm here with my colleague as well, Leila Mustafa.
Thanks, everyone. I'm a civil litigation staff attorney, and we appreciate you joining us today. Thank you.
Thank you. We appreciate it.